Today, next is William Messenger, and up next will be Joseph Poller. Good afternoon.
Thank you, Chairman, board members, for the opportunity to speak before you today. My name is William Messenger, and I'm with the National Right to Work Legal Defense Foundation. And also with me today is our legal director, Ray LaJeunesse. Now, the foundation is somewhat unique in that we don't represent employers or unions, but rather since 1968, we've been providing free legal representation solely to individual employees. And this includes in decertification and organizing campaigns. And of course, the very purpose of the National Labor Relations Act is to effectuate and protect the rights of employees, and not to effectuate the self-interests of unions or employers. And the Foundation largely opposes the proposed rules today because they invert the Act's purposes by putting a union's interest in obtaining certification before the interests of employees in learning about the pros and cons of unionization before being required to vote on it, and before their interest in privacy. Now, foremost, the Supreme Court in Chamber v. Brown recently recognized that employees enjoy an implicit right to receive information opposing unionization. The proposal to shorten the time frame for elections will impair the ability of employees who may not even have an opinion on unionization to learn about the pros and cons before being required to vote on it. And moreover, it will also impair the ability of employees who are opposed to unionization to exercise their Section 7 rights to engage in concerted activity in opposition to the union. Obviously, a union will be fully prepared to campaign before an election occurs, as the union controls when a representation election will happen. By contrast, employees could be caught flat-footed and unable to organize themselves before the vote actually occurs. And for this reason, the shortened time frame tilts the playing field against employees and in favor of unions. And second, the proposed rules contemplate a serious invasion of employees' personal privacy, namely, of course, the disclosure of their personal phone numbers, email addresses, and work times to unions and thus to union supporters. The 93% of private sector workers who have chosen not to associate with the union, or the tens of millions of people who have signed up for the FTC's no-call solicitation list, would likely be appalled to learn that a government agency is contemplating handing out their personal information to a third-party special interest group without their consent, or even potentially over their objection. And perhaps even worse, the contemplated disclosures place employees in danger from what union supporters may do with the information. Unions will inevitably share the personal information they've been given about employees with their supporters, to include some of the employees' own coworkers, for the purposes of supporting their campaign. And in fact, that's the very purpose for the disclosures. And once this information is given to a union supporter, it is quite foreseeable that union supporters can and will misuse this information in a variety of manners, including potentially without the knowledge of the union. For example, a union supporter could use the information not only to harass an individual who opposes the union, such as by late-night phone calls or signing them up for spam, but could also do the same to someone against whom they have a personal grudge. The information could be used by an individual to make unwanted contact and sexual advances on coworkers. I believe that many women in the workplace would not be comfortable with knowing that any of their coworkers who happens to support the union campaign could potentially learn her email address, her phone number, where she lives, and what time she gets off work. The disclosure of the information will naturally facilitate identity theft. A recent and prime example of that of Patricia Peltier, whose CWA supporters signed up for hundreds of unwanted magazine subscriptions and other advertisements in retaliation for her leading a decertification campaign against the union after obtaining her personal information. And finally, the disclosures could even lead to home burglary and theft of property because they reveal exactly when people work. If someone knows when you're at work, they obviously know when you're not at home. And the problem is there's no rule or restriction this board can impose upon a union to alleviate these harms, or fully protect against them, rather, because they're the inevitable consequence of unions sharing this information with their supporters. And once a union or anyone else shares information with someone, it can't fully control how it'll be used, it can't fully control who they may share that information with, and it can never actually retrieve that information back, as it can obviously be easily copied. The cat is out of the proverbial bag. And for this reason, to protect employees' privacy and to protect them from threats of harm by union supporters, I urge the board to not enact the contemplated disclosure rule. Thank you.
Thank you for being here and sharing your thoughts. Other questions?
2 questions. Go ahead, Mark. Do you have, you recited one example of an employee that was subjected to unwanted subscriptions because she led a decertification campaign. Do you have any kind of statistics on how prevalent union abuse of employees through information exists?
No, Your Honor. Mr. Honor, sorry. Force of habit. No, board member. I do not, at least at my fingertips. The foundation will be submitting much more detailed written comments before the August 22nd cutoff, and so those might have more details. But again, here, one of the bigger fears isn't necessarily what the union does with it, but once it gets out.
I see. Now, I got another question. You realize that those petitioners who file decertification petitions would be privy to this same information under the proposed rules. So an individual filing a decertification petition who wants access to information regarding the other employees would be entitled to getting phone numbers and addresses and emails as well.
Yes.
Would you have an objection to that?
Yes, the same objection. Once that information is given, and here, it's just to an individual. What rule or restriction can be imposed upon an individual employee who does a decertification election to safeguard that information? If that employee gives it to some of his supporters who also want decertification, the information can spread. And eventually that information can find its way into the hands of someone who will misuse it. For example, one of the supporters of the campaign may be a fine man, but his son might not be. And all of a sudden he has a list of everyone's phone numbers, email addresses, when they're not at home. There's a lot of damage that can be done with that.
Now, there's been prior testimony with regard to the insufficiency of certain Excelsior list information that petitioners have experienced, you know, outdated addresses, inability to contact people just by virtue of what is currently supplied in the Excelsior requirements. Do you think that those are valid considerations?
Only representing employees, I can't necessarily say of how accurate Excelsior list information is based on my own experience. Obviously, if there is outdated information on the Excelsior list, requiring more information won't solve that. Arguably, you'll just get more invalid email addresses. People change them all the time. Cellular phone numbers are also changed with probably more frequency than a home address. So as far as Excelsior lists being inadequate because they're inaccurate or outdated, the contemplated additional disclosures don't solve that.
Well, you would agree that all parties, all the stakeholders should have equal access to each other relative to an election campaign, wouldn't you?
Not necessarily. I believe that employees' personal privacy should trump over the ability of a union to contact them.
Okay. Now, employees usually have to supply this personal information to the employer.
Yes.
Wouldn't that give the employer the decided advantage in terms of communication?
Well, not necessarily, because first, how can the employer actually use it? For example, it's my understanding employers cannot conduct home visits. So having their personal address is an advantage there. How much can they actually use employees' personal email addresses to do things, even if it was allowed? But even more importantly, the interest of the Act is not balancing the rights of employers against the rights of unions. It's all about what is best for the rights and interests of employees. And I believe the threat to employees' personal privacy outweighs any kind of attempt to balance the electoral campaign between unions and employers.
So in that regard, it would be your position that unions should not have access to employee email addresses?
Yes.
And on the same token, you would not want employers to have access to employees' email addresses as well?
No, I didn't. And for an employer, as I said, they may already have it. They can use that realm of communication. And the fact that an employer can use certain communications or has certain information the union doesn't strike me as being particularly problematic.
I see. Thank you.
Member Beck.
Just following up, if the board were to conclude, for some of the reasons that Member Pierce was describing, that it's important to have an equal access to voters for purposes of communication, we invited comments on exactly the concern that you have, that is what would be appropriate sanction. That is, the proposed rules bar the misuse that you've described. That is, they require that the information only be used for the representation case proceeding. And we invited comments on what might be an appropriate sanction. Do you have any thoughts about that?
My concern is that since the purpose of the information is to allow union supporters to contact their coworkers, or in the case of non-coworkers, people in the bargaining unit. And the problem is, once the information is given out, what kind of control can the union have? So even if you have a union that intends to do nothing wrong, once the information is given, it's out there, and then therefore it could be misused. Now, of course, one could restrict the union so tightly on how it could use the information, but then that defeats the purpose. If the union has to keep it in lock and key in the union president's office, there's no point in the disclosures anyways. The only point of the disclosures, at least under the contemplated rules, is for the union to give it to their supporters to contact others. Once they do that, the union doesn't control it. It's out there.
Well, one could imagine a range of potential sanctions which would at least create an incentive to impose controls which would address your concerns. For example, you could bar, if there was such a misuse, you could bar disclosure in a subsequent petition.
But even with that, let's say the union in that example, though, didn't do anything wrong. Say the union, if there's 4 campaign supporters said, we want to volunteer to help, the union hands them the list, and then without the union's knowledge, one of them misuses it, or their son uses it, or whatever happens, it's out there. And once it's out there, you can't control the spread. And that's the problem. I don't see an appropriate sanction to alleviate that problem, other than not allowing the union to give it out to anybody. But in that case, it's useless.
Thank you.
I'm curious, just sitting here listening, and this is not part of this proposal, but I guess our last speaker ran off a list of proposals that he thought we should be considering, and one of them was equal access into the workplace. Do you think, as I said, it's not part of this proposal, but I listened to you and you seem to be interested in employees hearing both sides. Is that a way of avoiding these problems of giving out employees' phone numbers and email addresses and raising privacy concerns, to have a forum in the workplace where the employer and the union both can talk to employees? Is that a better solution?
It potentially could be, but of course it would require an amendment of the Act under Lechmere due to employer property rights. And it also creates the problem of the impression created of an employer conducting a meeting, with the union. Is this an employer sanction? How does the board even run such a thing, even if it was given statutory authority? It would be very troublesome.
Thank you for your comments.
Thank you.